Council, did you all have a chance to talk after yesterday? We've been looking at maybe setting this over to the 18th or?
The 18th is fine. I think your honor noted sort of a concern about sort of hearing the protection order side as well as the contempts and the family law side, and sort of the problems with the evidentiary issues that obviously are different depending on the type of hearing. I tend to agree. I don't think that your honor is incapable of making those distinctions. But I think what might be smart is to do the DVPO side on that date that you've referenced, and then set the contempts to a different day, maybe 2 or 3 weeks later, so that there's sort of a time separation between those. My thought is sort of the time separation then allows those things to sort of rest, and then the contempts to sort of been taken on their own merit, and then sort of the evidence is what it is, instead of sort of it all being sort of a fire at the same time.
Yeah, I did have a chance to think about it, and my concern, there was at least some discussion. I know there was a number of emails back and forth about potentially consolidating all 4 cases. That was really my concern, because there's obviously different evidentiary standards between the protection orders and the domestic cases. So as long as we don't do the domestic and the protection orders on the same day, that'll be workable. That was really my concern.
And we can even separate it and put the family law part of it out to July, a couple of weeks after. I have no problem with that.
Well, I don't want to go too far. My concern with that is currently the doing so on the case with the older children are 17 and change. They're currently prohibited from seeing their father at all. And there's a lot of issues with that, with children who have a lot of agency and can do things independently of both parents. So sort of saying, hey, we'll just keep banning them and set that out a long period of time. I don't want to do that either. So my thought is to do, to have, let's see, the court do the DVPO on the 14th, because looks like that was what was available for your honor. And then it sounds like you're not available on the 25th. So maybe either, and I don't know if the 18th is too soon for you, or the 2nd of July would be kind of my thoughts on dealing with the domestic side of things.
I can do the 2nd. I can't do the 18th because I'm not going to be in the office. I'll be working remotely. My son has camp in Portland. If we can do July 2nd, that will work.
That would be good for me. That will give enough separation. Plus, I'll have some time in the middle to kind of review everything on the family law independently. So if we move this to the 2nd, these cases, we'll address the protection orders on the 14th, and then we can, if we don't want to adjust something, we can also do that on the 14th.
Okay. And we may not even need to set the hearings on the 2nd at that point, depending on what occurs. I mean, who knows? We could even settle before then. So, which is still always the hope of everybody.
And then I did have one additional request, which time-wise, depending on if and when your honor wants to hear it, my client had, because the boys in this case, in the Ramos Shirley matter, the boys are 17 and change. It is unique to have children that are about to age out, and where a guardian ad litem report at 120 days is going to bring them a hair's breadth away from being 18. I had proposed that we should appoint them counsel, where you have a whole lot of adults saying, kids said this, kids said that, this is what kids want. Maybe we should just get it from the horse's mouth. And so I propose that we appoint them counsel, because given their ages and essentially ultimately what's being decided upon them, and an order that can't even last for a year because they're going to arguably age out of a protection order, and it gets to an odd place.
And Your Honor, I would ask that we reserve on that, and so we can present argument, because I think the GAL is the appropriate person for that. And I think her report is, I'm not sure if she's here today, but I think she mentioned she was going to have her report done very soon. I haven't seen it. So
There's
I
no
hate to have
GAL
more.
in that case.
Or there's a GAL in the other matter, and I know she's talked to everybody considering the cases are together. I would just ask that if we can reserve that for, even if Your Honor wants to make a decision off docket, so I can just do a little bit of briefing on that.
There isn't a guardian ad litem in the older children's case. And so because there's no guardian ad litem, there's been no guardian ad litem appointed in this case, in the older children's case. She isn't a representative for them. And I don't think that that's an appropriate vehicle. There's a statutory process for that should be followed.
This is Nathan and Judah, correct?
Correct.
That's correct, Your Honor. And you'll see and my concern is you'll see the missed calls last filing in this case, talking about how one of the children disclosed threats of violence by the father to him and about his other family members to him. And so my concern is that obviously an attorney is important, but I also consider that a GAL might be more appropriate in this case, given that all of these parties are the same. We have the same dad. We have two different mothers, but we have half siblings that are all related. The GAL's already talked to everybody involved. My concern is forcing these children or these 17-year-olds to speak to yet another person. That's just my concern without any briefing. Had I known that, I would have had something ready for Your Honor today.
Let me do this. I'll address that essentially off docket, but we'll discuss it on the 14th when we're here. If you want to file something, go ahead and do that. Send me bench copies as well as obviously the council. And these cases won't be on the 14th, but we can discuss it at that time.
Okay, sounds good. Thank you.
That would simply be the issue of whether or not they should have an attorney.
Right. Okay.
Sounds good. All right. Thank you, Your Honor.
Your Honor, number 7 on the docket, Dooley and Morris. We have an agreed set over. Ms. Gilmore is on the other side. And the parties have made an agreement on visitation between now and the set over. We're asking this be moved to June 18th. And then to put the agreement on the record, Mr. Dooley is coming into town June 12th through the 16th, I believe. And we'll have visitation with the kids, including overnight visits at his mother's home, at Mr. Dooley's mother's home. And Mr. Dooley will be able to take the kids to Great Wolf Lodge June 14th, following the child's birthday party, and we'll have another adult present with him.
And Ms. Gilmore?
Yes, Your Honor, that is agreed. I just note that the parties did agree specifically that my client would have overnight visitation at Great Wolf Lodge on the overnight of the 14th, and then would return to his mother's home on the 15th. I just also want to make it clear for the minutes that visitation isn't being stipulated to be supervised. It's just going to be taking place at his mother's home because my client's living in Arizona.
Agreed.
Okay. All right. So given that agreement on the record, we'll set it over to the 18th for
Yes, Your Honor.
orders.
Thank you.
Here on behalf of Mr. West.
Yeah, this was set over from a couple of weeks ago, I think, originally. And is the mom here?
She does not appear to be, Your Honor. It wasn't here, to my knowledge, when the court set it over previously.
So I guess explain this to me a little bit.
Yes, Your Honor.
I'm confused.
So this is a peculiarity in a divorce decree that is about 25 years old. In the decree filed with the court April 2nd of 1999, provision 3.8 prescribes a continuing restraining order restraining parties have contact, assault, harass, molest, disturb the peace of the other, indicating violation would be a crime under 2609-060, requiring clerk action. As indicated in the motion filed on behalf of Mr. West, some 20 plus years later, while attempting to get a concealed weapons permit, he's informed that this provision in this order is preventing both he and the petitioner, Mr. Gerard West, from lawfully obtaining or possessing a firearm. In doing some digging into the case history and the circumstances here, I believe that there's a deficiency in the decree as it relates to the restraining order, and the cleanest way of resolving it is just striking that continuing restraint provision. The motion identifies that it cites the wrong statutory basis for the entry of the order and the resultant criminal outcomes if it's violated. 2609.050 is the statute dealing with the decree and provisions of restraint in a final decree, not 060, which deals with temporary orders. There's also no expiration date, doesn't list a 99-year date. It says it's permanent. It's also not signed by either of the parties or their attorneys in that final decree. My client indicated in our declaration portion of the response or our motion that he's not had contact with her in over 20 years and has no means of being able to identify where she's residing. We did a couple different investigations to try and find an address for her and mailed to the last known address we were able to find. The other peculiarity about whether this was intended to be a continuing order is in April of 2020, about a year after the entry of the decree at Clerk's Papers 54 and 55, there is a motion by Mr. West Counsel at the time, Ms. Cotto, for a show cause to enter a restraining order that has operatively the same language as what was in the decree of dissolution. A temporary order was granted there until a final order was to be reached on property distribution issues from the decree. That happened, nothing more was done in the case. I don't think the parties or their attorneys intended or believed that this created a permanent order, and the absence of both the duration, the signatures, and specifically citing the wrong statute. The cleanest way to resolve this for both parties is to just omit or strike that from the decree or enter an order separately that the restraining provision from the decree is no longer in effect. But the difficulty here, admittedly, is because my clients had no contact, we didn't have a means by which to engage in personal service if we were to be moving to modify a protection order. I think because of the deficiencies, voiding the provision allows us to provide notice of the hearing by mail as attempted, as opposed to originating a new action. That's the route that we went, Your Honor. And it is as convoluted as one would expect from a 25-year-old decree.
I guess the question I have, and I don't have an answer to this because I haven't done the research on it, is the citation is incorrect currently. Do you know, did you check back in 2000 whether that provision was the provision in 2000?
It looks to be, Your Honor. I did look at the effective date and history of the statute, and this statute in its current form roughly goes back to the 70s. There was an amendment in 95. I don't have them all in front of me, but I did look at that, and it appeared to be the same to my recollection when I was researching. That was the reason I went this particular route, in all fairness, Your Honor, because I think that it, like I said, was maybe the cleanest way of trying to deal with a problem that the petitioner herself is most likely unaware she could be in violation of, but that's even if she is even still alive. Like, we've not been able to find anything directly other than an address updated maybe 6 months ago. We tried calling the phone numbers that were attached in the investigation that was done trying to track or find this person so that I could talk to them. None of that came. So this is what we did. If the court would like, I can submit additional briefing off the docket to show the form of the statute at the time was the same. And seeing as the other side didn't appear today.
I think if you want to prepare an order that accomplishes what you're trying to do, I think that given what you've put in your motion and certificates of service, it's probably appropriate.
Perfect. I'll do that. Thank you very much, Judge.
Okay. Thank you. And do we have Cassie Shevchuk present?
She called me something. She had something too. She said that they did come to an agreement outside of court, but she received a letter from Ms. Gilmore's office saying that she doesn't represent him, but we don't have a notice of withdrawal.
Okay, so My clerk was just advising me their office received a contact from Miss Cassie
Check.
Shevchuk indicating she had some sort of medical appointment this afternoon, was not available to be in court, but there was some agreement between the parties.
I haven't been contacted at all, and my client hasn't been served with any documentation. I only became aware of this when I saw it on the docket, frankly. So
Okay.
I don't know how the court wants to proceed. He hasn't been personally served. My office hasn't been served with anything that I'm aware of.
Okay.
I frankly thought that we would likely strike today, given the fact that the immediate restraining order was denied by the court a month ago. But I did want to appear.
Yeah, I was not inclined to, I didn't see any response or anything, but I wasn't inclined to grant adequate cause based on the documents that were filed, given the proximity to the decree. And the issues with the immediate restraining orders, most of the incidents were prior to the decree being entered, so it just wasn't appropriate. So I'll just strike it today, and then if it gets served, your client and you can decide what you want to do.
Thank you, I appreciate it.
So we'll strike it today.
Tiffany Jensen, present, Your Honor.
Good afternoon, Mr. Ball is present, I see. So I did not see a response in the file to the motion.
Well, Your Honor, we were, I guess I was a little bit confused by the motion to begin with. We were here on a review for the GAL, and then Mr. Ball filed a motion to compel without having a conference with me about what it is that he felt was deficient in our discovery responses. So, my reading of the rule is that, once discovery responses are received, that there needs to be a conference prior to filing a motion to compel. So I alerted Mr. Ball to that, to my understanding of that, on the 15th of May, and have not heard any response back from him. And so I wasn't sure if we were going to be proceeding with that today or not. But we were already going to be here on the GAL review. So if the court is interested in proceeding, I guess I would be requesting a short set over for me to file a response to Mr. Ball's motion. Or if we're able to have that CR26I conference, I can actually find out exactly what Mr. Ball thinks he's missing. Just a cursory review on particular ones in his motion, like interrogatories 41 and 42. He says the answer is unresponsive, but she did answer the question. So I'm not sure what additional information he's seeking on those. It would be helpful to have that conversation with him.
Mr. Ball?
Yes, Your Honor, I did have a CR26I conference, and as I submitted a follow-up email saying that complete responses would be due on the following Monday. And then if they were not complete responses, if they're incomplete, I would file a motion to compel, and then we continue to talk about it. Ms. Jensen's position is that I guess that I would agree to not file a motion at the time of our CR26 conference, and they could provide incomplete responses, and then I need to have another CR26I conference. So they haven't responded to the deficiencies that I've outlined in the declaration. I think is pretty clear that what we're asking for, I did have numerous attempts to try to hold the initial CR26I conference. In the first place, I had scheduled one that they didn't appear at, and then I tried to have another follow-up schedule. It took me a couple of weeks to even get one. And then Ms. Jensen emailed me and said, well, I can have one on May 30th, meaning that I need to have another CR26I conference. So I disagree with the interpretation of the law. They didn't file any response about that legal argument that they're making now, which would have been, allowed me to file some reply to that. I think I've met my duty there, and I think that the court should order the respondent to enter the order to compel that we've submitted. And then I think it's also necessary to have a review. Some of the issues that we're asking for are I guess there's some recordings out there of the respondent, and those were provided to Ms. Jensen, from what I understand, and those recordings have now been provided. That they could have filed a response about whether or not those recordings are in existence or not, and they decided not to do that and just show up today and say that I didn't have a 26i conference after all the effort that I put into holding that discovery conference. Some of the other things, you know, they didn't answer several of the questions there, and they provided incomplete answers to the other ones, like the there's some missing bank accounts and things like that. But and so I think that they should be compelled to answer the discovery requests, which are reasonable to try to move this thing on. Part of my concern from the beginning was that, you know, I was really pushing to get the 26i conference so that we could have this discovery to get the, you know, if it was, get the material to the GAL so she can complete her report. And the GAL's report was due today. I understand that that's not going to be submitted today, and it's not going to be some time out, but, you know, we're under a time deadline. So I think at this point, the respondent should have to pay reasonable attorney fees for not answering the discovery requests, and then the order should to compel should be entered. And then we do have two other matters. I guess we had a slight review of the parenting plan that was supposed to be entered, and then we're reviewing the GAL report today as well. Thank you.
Okay. The entry of the orders from the last hearing are not on the docket for today. Those were to be entered ex parte. Mr. Ball's attempts to schedule a CR26 conference is to basically dictate to me when I'm going to have that conference without taking any account into what my schedule is. So his assertion that I just didn't show for some conference was not one that we scheduled together or in an effort to have a legitimate conference about discovery. Additionally, the documents that he's requesting, I do not believe, and of course the GAL can correct me if I'm wrong, but I do not believe she's awaiting documents from my client to complete her report. I don't know where Mr. Ball thinks he has this information that I may or may not have audio recordings of my client. And frankly, audio recordings of my client may not be relevant at all to what it is that this court is having to decide today. So again, I would just request that this court require Mr. Ball and me to have a conference. We can schedule it again. And if we continue to have issues, I should have an opportunity to argue as to why the particular documents he's seeking are not relevant, and or that my client's responses were not quote unquote incomplete, because that's his perspective and likely is not mine.
So when
let me stop you for a second. So you said you had a conference May 3rd?
It's in my
declaration says.
I have a email there. So
I'm looking at the declaration you filed under oath, which I'm assuming May 3rd, and then you received responses May 7th after that.
Correct.
Did you have a conference after that?
No, Your Honor. I said.
Okay, then that's.
I said in my email that if I didn't, they promised me complete responses the following Monday, and then they didn't provide complete responses. So
okay.
I think, and I said in my email, which is submitted, that exactly that. And if responses and answers are not provided by Monday or they're incomplete, I'll file a motion to compel, and I'll provide a deficiency list so we can continue to narrow down the discovery issues. And then we're playing this game of chicken with me, because I also, when I issued my discovery request, I scheduled the CR26I conference to be on April 18th. And I said, if it's inconvenient day or time, please let me know in advance. And they didn't let me know. They didn't provide any discovery responses prior to that day when they were due. And so I think what else am I supposed to do? I mean,
well, let me stop and I can explain that. First off, you had a discovery conference on the May 3rd for your declaration. You received responses on the 7th, and you haven't had another conference since that time, correct?
Because they said they were going to provide complete
That's not
responses.
Mr. Ball, I asked
Yes, I already answered that question.
So you need to have a CR26I if you've got issues with the responses. This isn't, I don't know why we're even here. Because you had a motion, you hadn't received responses, you got them, you don't like them, that's time for a 26I. If you don't think that they're appropriate.
Okay, that's what your decision is. I'm not going to argue with you about that.
Well, I mean, you didn't have any responses when you had a conference, correct?
No.
And then you got responses, and you don't agree that they're complete or they're appropriate, which is entirely your prerogative. But then you need to reach out and go through the process. It's not necessarily a one-time deal.
I understand what you're saying, but I disagree that I have to have a 26I conference after they promise me complete responses. So, okay,
Well,
I'll do that.
you have a
And-
disagreement as to whether they're complete or not, apparently. And I haven't gone through and looked at them all because I didn't have a response. I didn't know where we're at, but
Oh, okay. Well, on the parenting plan, I know we're supposed to enter these off docket. We do have a disagreement, or the issue is whether or not Mr. Stemmerman is going to have an overnight parenting time, one time a month. And I thought that, we had filed a motion to adopt GAL's recommendation, which was to expand his weekly visit to 12 hours and then to allow him one overnight parenting, one overnight a month. And I thought that was ordered. So that's the remaining issue on the parenting plan.
Mr. Ball, it was not ordered. It very clearly
I'm
states
asking the
in the
judge,
notes,
Jensen.
it very clearly states in the clerk's notes, it says very clearly that beginning extended visitation to include overnights to be addressed at next hearing.
Okay, well, then
The
that's why we're
parenting
here. That's why
plan-
we're asking the judge about the overnight. So can we?
The parenting plan that you sent me included that language, and that had not been ordered. So it needs to be removed from that parenting plan for it to be appropriately entered per the court's last ruling.
Well, that's what
Now, if
the
we're-
plan says, is that after June 4th, that he would have an overnight. So that's what it says in the plan. So that's what.
That's not what it says. It says it would be discussed again at this hearing.
Okay, so that's where we're discussing that. So that's the next thing that I'm bringing to the court's attention, is to discuss this overnight parenting time.
just a second. So when I'm looking back through the notes, this was obviously a bit ago, a couple of weeks back.
Your Honor, if the court, when the court has a minute, I'm happy to kind of recollect what my understanding of the court's ruling was at the last hearing and what we were anticipating doing at this hearing.
So, and I don't have the GAL report up in front of me right now, but that's what I did. I adopted that report, which included Misty McKinney would be excluded.
Correct.
And then we were going to address extended visitation, including overnights, at this hearing.
That's correct. And the reason for that was we were awaiting Mr. Stemmerman's domestic violence report and compliance with treatment. We were waiting for Mr. Stemmerman's Love and Logic parenting certificate, which has been now submitted. And we were extending the visits from 7 a.m. to 7 p.m. And my argument to the court was that we should extend these things slowly. And that's why we were going to address the overnights at this particular hearing. And I think we were going to look to Ms. Height to see if there was any additional information or new information that she wanted to provide to the court. And I'm certainly happy to be quiet so she can jump in and speak. But that's my understanding of where we were and what was happening.
Well, that's based on what I ordered last time. I don't see a parenting or an order in the file, which obviously you're still working on that. Ms. Hyde, do you have any input into this at this point?
Thank you, Your Honor. Just to say that I do stand by my report. I do believe that overnights are appropriate. When I think back on the time that I saw Mr. Stemmerman together with his child, I had no concerns. They were playful. She was comfortable. They were mutually affectionate. It was very appropriate. So I'm standing on that part of my report. The other things that I'm waiting for going forward were some other things listed in the report for some a DV evaluation for Ms. Fontes. I did receive the DV evaluation information on Mr. Stemmerman. He is also going to be undergoing an SUD evaluation. So those are the things that I'm not waiting for information from Discovery. I'm waiting for some other things, which brings me to something I think Your Honor knows I hate to ask for. obviously my final report is not done today. It actually isn't started because I'm waiting for all of this important information. And at some point I need to discuss a date that's going to be appropriate to move that final report to. At this moment, I'm thinking probably optimistically that I could get everything back, evaluated, a report written, and to the parties in time for them to review it and respond. I'm optimistically asking for July 16th. I may live to regret that, but I think that would be absolutely the earliest. And as you know, I don't like to ask for extensions, but that's where we are.
Okay. Given the fact there's some things that are still kind of in process, that are, that seems not unreasonable to me. I don't know when we're going to have those other reports. I do see that we do have the DV evaluation and recommendation for Mr. Stemmerman, as well as the parenting class, which was filed with us May 24th. In looking at the recommendations of the guardian ad litem report, which was filed April 1st, which is the one we're looking at. Let me get to the spot. I was just there. And today being the 4th. I guess my thought on this would be to move forward with the overnights, and instead of using the first, since we've just shot past that, would be the second weekend of the month. So he would have this next Saturday to Sunday, this coming weekend, and then each second full weekend of the month past that.
Okay. Well, I'll let my client know.
Okay, and then we'll set a review on the final report. Does this, do you want to have a review on the 16th, or do you want a due date on the 16th?
Maybe it'd be best to have a review, just a review / due date, sort of as though we did today, just in case there's some hiccups. Ms. Height, I'll obviously defer to you, but I'm okay with that if Mr. Ball and Ms. Height are.
My input centers around how quickly we can get information back from the evaluators. I don't know where Ms. Fontes is in her seeking of a DV evaluation that is also ordered in this report. I know that Mr. Stemmerman is seeking somebody to do his follow-up work. So if everybody could get on board quickly, it may be that, as I look at my calendar, it may be if I could have a date of getting my report filed by the 15th and then reviewed by the 23rd, that would give all the parties a week. Would that give council enough time? I don't like to drop things at the last minute. I'd like you to have time to look it over and discuss it with your client. So that would give one of the things is that last half of July 4th week is probably there aren't going to be a lot of people around doing things on the 4th and the 5th. So if your honor would consider, I could have a due date of filing my report on the 15th with a review of it scheduled for the 23rd. I think that maybe is actually more realistic.
Council, does that work for you too?
Yes, Your Honor, that works for me.
Well, I guess my preference, just to be, well, anyway, is to just have a due date and without a review. And then if the report's not filed or something like that, we could, either party could bring it in and have it reviewed or something like that. But I think we're capable of communicating with the GAL about the status of that report. And so appreciate that she's being diligent and trying to get that finished, but I don't see the point of having a review
Well, at this juncture, if we shoot for the 15th of July as a filing date, circulation date for everybody. Typically on these, our review dates, we're really doing that to kind of monitor everybody following through and that sort of thing, which is, in this case, you got some things that need to happen before you can finish up. So my thought would be is to do a review on the 16th and just make sure that everything is where it needs to be, not anticipating anything other than just a check-in. If the report's done and filed on the 15th and the parties just shoot me an email, we don't need to have a hearing, I'll just strike it. It's really more of a check-in hearing at that point. I don't typically adopt any changes absent agreement based on a filing of a JL report. So.
Okay, that sounds good.
That works for me too.
Due date, hopefully the 15th. And if it looks like we're having issues, come in on the 16th at 1. And if there's no issues, shoot me an email. We'll just strike it. Okay.
Thank you.
And I did have one clarification, Your Honor,
Yes.
on the parenting time. You said it was Saturday to Sunday, but I have it from 7 a.m. Saturday to 7 p.m. on Sunday, which I believe are what the
I believe that's what the report recommended.
Okay, I just want to be clear.
And that would be starting this weekend and each second weekend of the month going forward until we have other orders.
Okay.
Your Honor, the one other issue that I think was set for discussion today was the handoff location, moving. I know we had some discussion last time about moving it from the hospital location to Jansen Beach, and I didn't know if you had any more thoughts on that. I still prefer that. I still think it's a location that has better security and it's closer to the I think it's just is more convenient for everybody. But I noticed that was set for another look today.
Council, did you have any thoughts on that? I know my preference is not have to go through Vancouver or North Portland on any day of the week, frankly, but I tend to go the old highway, but that's just personal preference.
Well, the hours are set, like the 7 a.m. should hopefully on a Saturday be, again, I'm optimistic, thinking on Saturday traffic at 7 a.m. shouldn't be too bad, but that's my preference, and I know that's just one of several.
Council?
I believe my client would like to keep it at the location it currently is. That's where they've been doing it. That's where they're comfortable. That's where Hadley's been doing it. I agree with Ms. Height that I don't think traffic will be horrendous Saturday morning at 7 a.m. But in my experience, traffic leaving the Portland area Sunday evening, heading back towards Vancouver can be quite difficult. And I've experienced that myself. So the 7 p.m. at that same location might be a bit more challenging. I guess that's all I have to say about that. I think my client would prefer that it just stay at the same location that it's been.
Mr. Ball?
Yeah, I think my client wants to have it at Jansen Beach. I think a compromise would be to have his parenting time end at Jansen Beach. Or I guess the other way around, begin at one of the others so that maybe they can avoid some traffic that way. Or I think Miss Jensen's correct. If you're coming north Sunday at 7 p.m., it tends to get backed up a little bit. Or in the evening on Saturday.
Your client's in Longview, Mr. Ball?
I think he's in Woodland.
He's in Woodland.
Woodland, okay. All right, that's I'm not sure Jansen. It'd almost make more sense to go out to the east side and go over 205, which is probably less of a traffic nightmare, but.
Yeah, that adds a little bit more time to it though. Because if you go 205 all the way to Sherwoods, I don't know. It just depends, I guess. But there's no right way to do it, I guess.
Yeah, there's no good answer. I guess my thought is for right now, I'm going to leave it where it's at just because that's where it's been working for the time being, and we're not changing the timing significantly at this point. So yeah, if it was in Longview, I would say go through Rainier because that's actually faster.
Oh, yeah. Yeah.
But Woodland kind of puts you in a bad spot. I guess my thought on that is you can take a look and see if you can find some alternatives. It's very possible going out to the east side traffic wise might make more sense if there's a lot of spots out there, but at this point I'll leave it at the hospital.
All right. Sorry to open that can of worms at the last minute, Your Honor.
It's okay. All right. Anything else on this one today?
Not for me, Your Honor. Thank you.
Okay, thank you, Your Honor.
Okay.
Thank you, Your Honor.
You're welcome. Okay. All right. So when we were here last, which was a couple of weeks ago, a few weeks back, let me pull my, it's loading here. I looked at it before we came in today, and we were here on May 7th, and there was a declaration that had been filed on April 30th by Ms. Steinweg. And did you receive a copy of that, sir?
No.
Okay, I thought you were going to get a copy from the clerk's office.
Yeah, he was supposed to pick that up the day that we had court.
That's what I had down in my notes, is you were gonna pick up a copy from the clerk's office when we were here. So you didn't do that?
No.
Okay.
I'm sorry. I'm not sure what it is.
Well, it was the declaration that she filed on the 30th about her concerns about some issues at issues at a sports field and some other things like that.
All right. No, I didn't pick that up. I apologize.
I don't have a way to print that.
I forget that, that's where attorneys come in handy for me, because I don't know. Now I like have a UA result from my treatment facility to give to the court, but I have to have one for her and one for the court. So I don't know I also took a UA today for them. My treatment facility is like so packed with people. I had a meeting with the head nurse there to get more UAs, and it was supposed to start happening like once a week. And I've had to go in and bug her twice. It's not her fault though. It's just, I think, how flooded they are. But I did take another UA today, and supposedly I'm going to have weeklies for a few weeks to show that how I'm doing.
When you were here last, which was 3 weeks ago, I think, a little 4 weeks ago, you had a compliance letter of some sort with you. Do you remember that?
Yeah.
Did you file that with the clerk's office? Because I don't have it here.
You don't have it there? Okay. I guess I didn't file it with the clerk's office.
Okay. All right. So here's the problem, sir. She's raised some concerns having to do with you going to the sports field when you were not supposed to be there, supposedly, and different things like that. We were here on the 7th of May, which is about a month ago. You had a letter with you of being in compliance with treatment. I didn't look at it. You were going to file it and get a copy to her. Did you get a copy of that, ma'am?
No, I haven't received anything.
Okay.
And I said that I would take it via email as well.
Right, I see that. And you got a drug test you've done, which I don't have, she doesn't have. And it's been a month. So do you see the problem here? Okay. I think everybody has an interest in having you being involved with child, but you got to do your part of this. I mean, if you show up with a letter and you didn't file it, and I told you to file it, and it's right here, and you were going to get a copy of her declaration from the clerk. And you specifically told me that. And so we're here now a month later, and then none of that's happened. And I'm not questioning you've been going to treatment, but I don't have documentation that you've been going to treatment.
Okay.
You understand?
I do.
Okay. So, and I'm just going to be straight with you here. You're in a situation where you're kind of digging out of a hole. And so you've got the work to do here.
Okay.
So what it sounded, and ma'am, if I read your request correctly, the biggest thing you're asking is that if he's going to go to any of these public things, he needs to be supervised. Is that accurate?
Just for the first 6 months that he's waiting to pass UAs or turn them in or whatever that may be.
Okay.
And the next couple months, there won't be any events anyways, because it will be summertime, so he won't be in any sports probably over the summer.
Okay.
And the last track event that he did have, I know that Zach's grandma did attend while Chris attended, and that was fine. She said that she would make sure that nothing happened, and it was fine.
Okay, so here's the thing. I need to get this case to a place where I can get a final order in it. Because we had a trial and we've kind of continued this on because you looked like you were making a lot of real good strides. And I have no reason to believe you're not doing that, but I don't have any evidence that you are. Other than you look like you're doing okay. And that's good. Okay, and you're showing up for court like you're supposed to. So what my thought on is this thing is I'm going to require that if you go to any events is that you have somebody with you who can kind of like, is it his mom that was?
Yeah.
So your mom needs to go with you if you're going to be at an event.
Okay.
Okay.
All right. I wish I had the other paperwork because other things in my life that's been going on throughout the last year, I finally have positive.
Okay. I like to see that. So here's what I want you to do. Okay. I'm going to set one more review on this thing. It's going to be out about a month and a half from now. I want you to put together all of this documentation about what you're doing, drug tests, letter from your counselor that you're in compliance, those kinds of things. Anything else you want me to consider, I need to get it filed with the clerk. They don't charge to do that.
Okay.
They'll even give you a cover sheet for the big packet. I want you to file it, but you need to make a copy of it and email it to her.
Okay.
And in the meantime, you want your mom to be with you for any events like that. And when we come back and I'll pick a day that's going to work for both of you. My inclination would be at that time to be plan on entering a final order in this case so we can kind of get you guys away from the court system.
That would be nice. Now the UA I took today, the results should be back before Friday, I would think.
Okay.
So I can email both copies to her or and anything else that I need to turn into the court. I'm okay to just email it to her.
That's what she said. That's fine.
Okay.
Correct?
Yes.
Okay. So anything you want me to look at that you're going to file, email it to her first and then file it with the court. So we're all looking at the same stuff.
Okay.
I have great hopes that you're going to do well, sir. You've made a lot of progress.
It doesn't look like it, but yeah.
Well, I mean, I don't have a lot of negatives. I got some concerns raised in this declaration, which you should get a copy of that from the clerk's office so you know what we're talking about.
Okay.
Go out there and they'll charge you under $1 probably or $1 for a copy of it. Okay. All right.
I'm also, can I ask one more question?
Oh, yeah. Sure. Go ahead.
When Ms. Schaefer did her report, it said that there was no mental health ROI signed and there were no Kaiser Health records that she had requested from Mr. Olson, was that ever taken care of, or I haven't received any paperwork on that?
I do not believe so. She made her report based on what she had available.
Okay,
It was basically the core health stuff.
I haven't heard anything on it either. I don't know.
well, an ROI wasn't signed by you, so,
Yeah, it was, though, at both my treatment
Okay.
facilities. I don't know. What about summer? Summer schedules usually week on, week off. My mom said that could continue depending on what the judge says. I don't know where we're at on that.
we're going based on the investigator's report, which was every other weekend supervised.
At this point, it's every other weekend.
Okay.
I mean, I'll be happy to take a look at but again, I need to see the stuff that you're doing.
Okay.
She needs to see the stuff that you're doing to document that this is what should happen. And so this is all in your lap at this point. You got to bring the stuff forward so we can look at it. Okay?
All right.
Okay.
Thanks.
You gotta understand something. I ran our drug court for about 9 years. So I'm used to dealing with folks who have your situation going on. And me holding you accountable to do what you need to do is probably the best thing that's going to happen. So it's what's going to get you to get your stuff done. Okay?
Okay.
So how about if we set a hearing, how about this, maybe the 9th of July, that's right after the 4th. Is that a workable day for you both? It'd be on this docket.
I guess my concern is he going to have 45 days clean at that point, or are we just wasting our time because that's not enough time to
As
even change the schedule?
of 5/13, I assume that's when we start my time, is when I submit my first clean UA, correct?
Well, I don't know. I haven't seen a clean UA
Okay.
yet. So
Okay. Well, yeah. Okay. Anyways.
you have 45 days clean at that point.
Yes. Absolutely.
Okay. Well, if you're both available on the 9th, it seems, part of my problem here is I don't really want to give you too much leash because it's just going to keep dragging on and on and on. I want to set a deadline to get this thing taken care of. And if you don't get the paperwork filed, you're going to end up kind of where you're at, which is supervised visitation. You understand that?
I got you.
Okay.
Again.
Let's shoot for the 9th of July if you're both available.
At 1 p.m.
Okay. And then I need something from your counselor that tells me that you've been clean all this time. Letter from your counselor in treatment. Your drug tests. Anything else you want me and her to look at to make some decisions about what should happen going forward?
Okay.
Okay.
Thank you.
Okay. Make sure you file that at least a week ahead of time.
Okay.
Probably a little more with the 4th. So, but by the end of June, file everything you've got.
Okay.
Okay. And email her everything.
Thank you.
Okay.
Thank you.
9th of July. All right. And with that, we will adjourn.